Good morning, everybody. Welcome to this pop-up seminar or webinar dealing with the implications of the decision of the High Court in Van Wyk and others versus Department of Labour. My name is Peter Leroux. I will be the informal chairperson of what I hope takes the form of a discussion of the topics involved. The speakers who will be doing the hard work are Henry Rossouw from Cape Town, our director there, Lauren Salt, a director from Johannesburg, and then Balindile, also a director. All three of them have extensive experience in labor law, as well as dealing with the Basic Conditions of Employment Act, one of the more problematic pieces of legislation, in my view, in any case, for labor lawyers. The experts tell us that we should not have a webinar like this that lasts more than 1 hour, 60 minutes. We have tried to design the presentation in such a way that we do comply with the requirement, and also that we have a bit of time for questions. If you have questions, I see there is a Q&A box that you must utilize. Please utilize it, and we will, if we have time, try and deal with some of the questions. I suppose we should also just mention briefly what we are not dealing with. You will realize that not only does the decision suggest amendments or require amendments to the Basic Conditions of Employment Act, it also amends the corresponding amendments in the Unemployment Insurance Act, dealing with the benefits that these people, or the people that we're dealing with today, will be entitled to. We aren't going to deal with that section. If it becomes necessary, that's another webinar that we can deal with. So we're going to concentrate on the BCA in this regard. I suppose with that brief introduction, and in the spirit of trying to keep to a tight time schedule, let's start with Bali. Bali, can you start with us and say, what is the exact impact at present of this decision? How does it impact on the day-to-day running of the business at this stage?
So perhaps, Park, I think most of us have seen the pandemonium that this judgment happens to have created in the employment sphere. And if we can just give our audience this assurance, well, even though it's not expressly set out in the judgment, because the judgment says it is with immediate effect, any judgment or order of a high court that pronounces any legislation, in this case the BCA and the Unemployment Insurance Act, to be unconstitutional and therefore invalid, must be confirmed by the Constitutional Court. Until such time that it is confirmed by the Constitutional Court, it would not take effect. So we are expecting one of two things: that the matter is now being referred straight to the Constitutional Court for confirmation. Of course, we'll be keeping our eyes peeled for further developments, because one can't completely rule out the possibility of an appeal by one of the respondents, although we haven't heard anything to that effect now. So, I mean, to give some sense of timing, although this is generally not within the party's control, the last judgment, or last popular judgment rather, that dealt with a constitutional invalidity and had to be confirmed in the High Court was the famous Prince judgment dealing with cannabis and the use of cannabis. That judgment was, as I understand it, handed down on the 31st of March 2017 by the High Court. It was ultimately confirmed by the Constitutional Court on the 18th of September 2018, some 18 months later. I'm not suggesting that this will be the same timing. It may be accelerated, it may be longer, but what is definitely certain is at this very moment, the amendments pronounced by the High Court judge have not taken effect. So employers have some breathing space to collect their thoughts, to consider all the issues that arise out of this judgment, and to prepare themselves for an eventuality where the whole or parts of the judgment are confirmed. Park, you are muted.
Thanks, Molly. Look, as a starting point, we must start at the beginning. What does the Act say present, and how do the amendments impact on the present situation?
Okay, so there's currently 4 types of parenting or parental leave, if you will. It's the classic maternity leave, which we know is granted to the birth mother, which is the 4 months maternity leave, and embedded within that would be a 6-week period where an employee may not return to work unless a medical practitioner or midwife certifies that they can. Embedded in that also is the 6 weeks that an employee who miscarriages or has a stillborn child can also get. So that's the one category. Then there is what is called parental leave. Parental leave sometimes is incorrectly referred to as paternity leave, but essentially it is the 10 days which a parent who is not the birth mother and who is not a primary caregiver for the purposes of adoption and commissioning leave, I'll come to those now, will get. So fathers typically will take this type of leave. Then we have what we call adoption leave. Adoption leave, which is a species of the 2015 amendments, is leave that is granted to adoption parents of a child that is 2 years or younger, and that is the 10 weeks. The 10 weeks may be taken by only one of the adoption parents, and the non-primary caregiver then takes the parental leave that I've referred to earlier on. The same with commissioning parent leave. Commissioning parent leave also can be taken by parents who have a child as a result of a surrogacy arrangement. And again, the primary caregiver gets 10 weeks. The non-primary caregiver gets their 10 days of parental leave. So that's what's the situation that we start off with. We then, what brings about this court is Mr. and Mrs. Van Wyk, who are a married couple, they have a child. Mr. Van Wyk is employed, and Mr. Van Wyk is employed, and Mrs. Van Wyk is a business owner for her own account. They look at the circumstances and they decide that it is most suitable for them, for Mr. Van Wyk to be the primary caregiver, because Mrs. Van Wyk cannot be away from her business for various reasons. However, Mr. Van Wyk doesn't have access to the classic maternity leave. So he ends up taking parental leave 10 days and then takes a combination of paid and unpaid annual leave. They piece things together.
Molly, can you hear?
Great consternation. Lauren, if you can just give me a thumbs up if you can hear me. Perfect. Okay. All right. Thank you. So that's what brings us to this. So ultimately, the judge looks at this and says, listen, there's no reason why you should be differentiating between 2 categories or different categories of parents. All parents, irrespective of whether they're male, they're female, irrespective of whether they are parents because of adoption, because of commissioning parent, doesn't matter the circumstances that give rise to them becoming parents. Every parent ought to be entitled to the same amount of leave, and that is 4 months of leave. It then says, dear BCA, change what you currently call maternity leave and call it parental leave. So every parent is going to be essentially entitled to 4 months of parental leave, still unpaid, that doesn't change. But where there are 2 parents, then those 2 parents will share this 4 months. Where there's 1 parent, the 1 parent will take the whole of the 4 months. So that is, in summary, the one important outcome. What it also appears to do is then create another subspecies, which is birth mother leave. So it appears that birth mothers will still be able to take the leave, the 4 weeks leave before they commence, before they give birth, and that they will be able to take the 6 weeks leave, which is essentially the convalescence leave for the purposes of physiological recovery.
Thanks, Barley. I suppose the question is, do you think the next step is either for the legislature or the Constitutional Court to decide what the actual position will be? Is there any chance that do you think that the legislature will change anything in this as a result of this decision? Do you think they will follow the decision completely, or do you think they will go their own way, or can they go in their own way? Lauren?
Thanks, Pax. So if it's anyone's guess really what the outcome will be, but the Con Court is not bound by what the High Court has determined in this interim arrangement. So there may be nuances that come out of the Con Court's decision that may be process related, that may be clarity related, and they may be completely different at all. But there is a body of guidance that they can take from overseas jurisdictions who have got very similar parental leave regimes. So we may see some of that coming out in what the Constitutional Court confirms or changes, as the case may be.
What I find interesting about this judgment is the idea of, or some of the underlying assumptions that the court makes in this regard. This idea that from the Children's Act, there's this idea of the role of the leave is a sort of almost a nurturing function. Can you see any other policy? Is it possible that the High Court could, the Constitutional Court or the legislature could take into account other policy assumptions that can change things?
Puck, it's quite possible, and the judge in the High Court has recognized that there is certain information that has potentially been withheld by the minister in the court application that may well vary or may well lead to different policy considerations and assumptions at the Con Court stage. So there may be other factors at play here which change or give a nuanced effect to the policy considerations that we've seen at current.
I think that's right. Balindile, payment. And what about fathers? If the employer has a policy in place which gives a birth mother or a mother paid maternity leave, could that impact on fathers in the new situation?
So in my view, Park, an employer who offers paid maternity leave to birth mothers would struggle to have a rational, reasonable justification for not paying the same type of benefits to a father or a non-birth mother. So let's call it a mother by way of adoption or commissioning parent, the same benefits. They would have to practically bend themselves backwards to come up with a justifiable reason, in my view. So they may, if they pay one category of parents and not the other, they may very well expose themselves to an unfavorable practice and also potentially an unfair discrimination claim on the basis of sex, gender, and the like.
Yeah, I think that's going to be a question for the future, I must say, how that's applied. Then the question that's interesting to me is, will a surrogate mother or a birth mother of a child that's adopted at birth be entitled to any parental leave?
So the BCA as it currently stands does not expressly deal with it, and neither does the judge. But I've always been of the view that Section 25 in its current form, which says every employee is entitled to 4 months maternity leave, would have covered a surrogate mother or a birth mother who gives up their child for adoption and no longer becomes the parent. It seems to me that the amendments the amendments by the judgment also preserve that type of interpretation. So in my mind, the surrogate birth mother and a mother that gives up their child immediately for adoption still have access to the 4 months before giving birth. I mean, I beg your pardon, the 4 weeks before giving birth and the 6 weeks immediately after giving birth. I think those leave protections have been preserved for them.
Thanks. Henry, during our discussions, I know you've had some views about the idea whether the 4 months leave should be shared or should not both parents, as it were, get the 4 months leave. Have you any views on that?
Yes, Puck, it's a difficult question. You know, where we're seeing employees receive more than than they currently have. But some questions have been put to say, could it have been even more? Could it have been even better? You know, this sharing arrangement, which I think we've seen from some other countries across the world, is a better one for certain categories of employee who wouldn't have had this type of leave at all. But it's also worse for certain categories of employee. Simply put, the birth mother who would have had 4 months free and clear may now have to share the 4 months. So the simple question is, why didn't we just make it simpler? Why not both parents get 4 months? Then you don't have to share it, you don't have to do declarations, any of that stuff. And I think the simple answer is, well, that would be nice in perhaps a different economy, in a different country where the pressures are not such on employers operating at such fine margins, where things like this, if you have 1,000 employees, and this is going to have some kind of material impact on your workforce, or if you have 2 employees, and this is going to have a material impact on your workforce, the difference between something like that can be make or break. So I can understand the reasons why. I can certainly understand the question. The question is a fair one, but I can also understand the reasons why the judge in this case, and potentially the legislature when they consider it, may go only this far, if you want to see it that way. What I think it does is raise 2 interesting questions for employers to say, assume these amendments are passed as is. They are, of course, as we know from the BCEA, the minimum entitlements only, and you can provide better benefits than that. So for employers that are already providing enhanced benefits, is there going to be a consideration of enhancing the benefit even further and saying, you know, this sharing the leave and who gets this and you get 1 month and you get 3, you know, that's very complicated and an administrative burden that we don't want. We can afford to offer both parents the 4 months. Then we don't have to deal with all of that stuff. Conversely, is it going to be an issue for employers who are currently offering more favorable paid maternity leave, but under the current regime, or the old regime, if you want to call it that, now they're going to have to provide minimum benefits to other employees who wouldn't otherwise have received it? Is that going to eat into their capacity to provide this more favorable benefit to mothers? And instead of a better position for everyone, is it actually going to result in a worse position for some? I just think those are some interesting things that employers are going to have to grapple with.
And just to chip in there, Henry, I think, you know, quite right on the point about the economy, and from the judgment, it's clear that the minister was making those submissions. We cannot compare ourselves necessarily with other countries where there are first world benefits provided. And if we're looking at other jurisdictions, and particularly the first world jurisdictions, there's these 2 pillars of benefit provided. So the one where it is shared and the one where it is separate benefits that run simultaneously. So looking at the UK as an example, there's 52 weeks of maternity leave, of which 50 is shareable. So if a mother takes less than the 52 weeks maternity leave, she will take her 2 mandatory weeks. The remainder of the 50 weeks is up for sharing between the parents. If you look at Germany, on the other hand, they've got extremely generous parental leave where both parents can take 3 years each of parental leave. So, you know, combined, that's 6 years running simultaneously, potentially up until the child's 3rd birthday. So I think when looking at other jurisdictions, there are a number of other things at play, but certainly the debate as to whether it should be simultaneous or it should be shared is one that doesn't just exist in South Africa following this judgment.
That's right.
Yes, thanks for that, Lauren. The other question that we found quite intriguing is if a father, if an employee fathers more than one child in a year, will that person or that father be entitled to 8 months parental leave? And Henry, you had some thoughts about that as well.
Initially,
Easy answer and the
more
difficult
interesting question. I think the answer is a straightforward yes. I think it begs some interesting questions, or provokes some interesting questions around the kind of proof that employers will be entitled to ask of employees other than the birth mother who are taking this leave which was previously not afforded to them. And I think the question is twofold. It's what will the legislature see fit to say an employer is entitled to ask? Because of course the BCEA has types of leave where proof is required in certain circumstances. So family responsibility leave, for example, if it's the death of a close family relation, you have to provide the death certificate, or at least you can ask for it. You know, in terms of sick leave, if you want that leave to be paid, then there are certain circumstances where proof is required. So I think that's going to be a very interesting thing to see how the legislature resolve that, if they resolve it at all. And if they leave it up to employers to decide, that's going to be an even more interesting question, something where we can wade in and give our views on, you know, what is reasonable for an employer to ask of someone who is not its employee, because now we're assuming potentially you're asking someone else for that information. You know, must you then, can you delve that deep into a very personal matter to ask for reasonable proof? And the answer might well be yes, but it's a question of how far can you push it. My sense is that some proof may well be required, but how far the legislature sees fit to push that, we don't yet know.
And just to chip in here, Henry, although there doesn't appear to be any restrictions on multiple births by different birth mothers in terms of parental leave overseas, there does seem to be some kind of enhancement where you have multiple births of the same birth mother in relation to the same pregnancy. So in some jurisdictions, you're seeing a situation where if you have twins or triplets or more than that, your leave is extended by a certain period and your benefits may be enhanced by a certain amount. So it'll be interesting to see whether any of that guidance is carried through into how the legislature ultimately implements the amendments.
Agreed. I don't know. We had our two children separately, and that was already a lot. I don't even know how you start to have twins, triplets. I think you must just take leave indefinitely and just say, look, I'll see you again when the kids are grown.
Yes, I share those feelings. I can dimly remember those events, but I can remember them being very tiring. That's all I can say. Another question that we debated, and I think it's an important one, this idea that you've got two parents, they both have to work to keep the money coming in, and they ask the grandmother to help out and to look after the child while they are both working. In other words, almost a type of stepmother, inverted commas, or stepfather type of relationship. That stepmother or stepfather, should they be entitled to leave? Are they entitled to any sort of leave in terms of the new amendments? Lauren?
So Pak, that's a really interesting question, and it goes to the heart of the interpretation of what a parent is. In the wording of the judgment, it's fairly specific. And if you look at also with that, the Children's Act and how they describe a parent, it is quite limited to that person, which is a genetic parent or in some kind of arrangement where there's a surrogacy. So it does not look like it extends to third-party carers. But again, that doesn't mean that that's necessarily going to be the case ultimately. So if you've got a mother who has passed away at birth and perhaps a single parent, there is a possibility in which there could be some kind of transfer to a carer if there is an absent father in that example. And that is some of the more recent amendments that we've seen in the EU. So there have been a number of changes to recognize carers that are not birth parents in the EU over the last few years. So whilst that may not make it into the current wording that has been issued by the judge, it may make it into the amendment depending on how far down the line that is, or it may make it into further amendments in the future. So at the moment, it doesn't look like it caters for that, but it is a possibility that we'll get there.
Sorry, perhaps, Park, if I can jump in there, and I think, Laura and I agree with you as to what the legislation will choose to do in the future between the BCA and between the definition of parent in the Children's Act. I guess we all are waiting to see that. But it seems to me that one of the fundamental drivers for a person to be able to attain that right would be for that person to have a legal right of care and responsibility towards the child. So I suspect then if that happens, then that might see the law developing in that particular direction.
Agreed, Bali.
And I suppose if you look overseas, many European countries at least have fairly extensive preschool benefits for employees. There are places where you can take your child to, at state expense and that type of thing, and they become the carers almost. In our law, we won't have that possibility. I mean, we simply don't have those facilities available, and it'll be interesting to see how that's taken into account. The other question: can the employees take parental leave simultaneously? Henry?
Again, on the face of it, I think a simple question. This time the answer is no. If you look at the judgment, the wording that's proposed at the moment is, and this is reading directly from paragraph 4 of the judgment, replacing the section 25(1) provision in its entirety and adding in, employees who are a pair of parents are collectively entitled to, and then one or other parent shall take the whole of the period, or each parent shall take turns at taking the leave. Now, I imagine that once the legislature get their hands on this, they might finesse the wording a little bit there. But it seems to me the thrust of all of this is an acknowledgement that there's a need to nurture newborns for a certain period of time, rather than that there is a need for a certain number of people to nurture a newborn. As in, what seems to be important is those first 4 months are critical. Someone must be there nurturing that newborn, rather than let's have 2 months where both parents are there doing really a lot of nurturing, and then after those 2 months, no nurturing at all. So my sense is that that's what it says at the moment, but I also think that was the intention, and that will stick once the legislature get their hands on it.
In other words, there must be a nurturing of at least 4 months. Is that what either by 1 or 2 people? It doesn't have to be both. Yeah.
I don't know if we can say must be a nurturing, but at least parents are entitled to
it, yes.
Yeah.
Quite right. The act isn't prescriptive, just as it isn't prescriptive now as to what you must do with the leave that you're afforded as a birth mother. It's assumed what you're going to be doing, but it hasn't prescribed, and I don't think it can. The same would apply here. So you're afforded that benefit such that you can nurture.
So if you take 4 months off to go to the coast or something, you may be abusing it, but you're entitled to do it.
I'm one of the wily fathers referred to very briefly by the judge in the latter part of the judgment. Yes.
And what did he say about those wily fathers, the judge?
I think he was dealing with a different issue to say, that this benefit is susceptible to abuse by, for example, wily fathers is not a reason not to confer the benefit on 99 out of 100 other parents who are not the wily fathers trying to abuse the system. But I think that also does lead to the necessary conclusion that just with all the other types of leave that could be abused, this is a very particular category of there may have to be policies drawn up, and employers might have to think quite carefully about how to prevent abuse, how to monitor abuse. And that all comes back to those questions about information disclosure and how far we can push it about double checking that this is in fact your third child that has been reared by a different mother in the same year, to give an extreme example.
Yeah. And this is a question that's reflecting in the question. This is an issue that's reflecting in the questions coming up. What are the practical considerations if parents are not employed by the same employer? Two employers, one employed by the father, inverted commas, and the mother, inverted commas. What are the implications of that? Lauren?
And I think this talks to Henry's point that he's just alluded to, that there needs to be some kind of verification potentially and some kind of disclosures made. Remembering that the employers, on behalf of the employees, if they're going to claim from the UIF, will need to make declarations as to the period of the leave that their particular employee is taking. So my employee, the mother, is going to take 3 months, and the other employer is going to say, my employee, the father, is going to take 1 month. So there's going to need to be some kind of disclosure between employers and to the UIF to confirm that there is then no fraudulent claims made to the UIF in respect of the benefits, because the UIF is going to ultimately need to understand who the mother is and who the father is and how they are splitting their statutory entitlement in order to determine whether or not they are entitled to the benefit claimed. So there is going to need to be some kind of disclosures between the companies of the respective parents.
So it'll be up to the employer really to ensure that there's compliance with the UIF, so that employer will have to know what leave each person is getting, or each employee is getting, if I can put it that way. I think that's correct. I suppose the question about false information comes to the fore here. Henry, you and I discussed this, and I thought you had some interesting views on this.
Yeah, I think, as with the other types of leave and potential abuse, if false information is provided by an employee in relation to this category of leave, I think you treat it as you would treat any other type of dishonesty, which would be an issue of misconduct and potentially dismissible, depending on the gravity of the lie and the deceit, effectively. And again, I think that goes back to how much information are you going to ask so that it can't be said that, you know, the employee in question was entitled not to give you that specific piece of information. I mean, the clear-cut cases I don't think are going to be too controversial, where you have an employee who plainly isn't a parent by any definition, trying to claim, you know, the balance of the 4-month period when they haven't parented any child at all. Those are not going to be the controversial ones. But my sense is the more difficult ones, the hard cases, are going to be in the nuance of the exact information that you ask and the quality of the information that you get back, both from your own employee and, importantly, someone else's employee.
And I suppose there's a lot of sensitive private information involved in that you've got to worry about.
Sensitive private information, and I also think, I think we spoke a lot about kind of employee education. You know, this is something that we've never had before, not anything like this. And although the BCA is written in a fairly accessible fashion for non-lawyers, somewhat, I think this takes a fair bit of explaining, so that particularly an employee who's giving up a right to which they're entitled can understand what they're doing when they're saying, no, it's fine, I'll just take my bare minimum 6 weeks of birth mother leave, and my other partner or parent is going to take the balance. It's important that they understand what they're doing there, and that they have an election, and that has to be by agreement between the two parents, that the employer doesn't get to play any role in that agreement at all.
And when you say that, Henry, it makes a lot of sense to me, especially, you know, what we were talking earlier on about whether a father who fathers more than one child in a year can then accumulate potentially 8 months of parental leave. And I agree with you, the answer is absolutely yes. But part of what the education does is, to the extent that an employer's policy has limitations on how much it will offer in relation to paid leave. So I've seen policies which say you will not get paid maternity leave unless you've been with us for a year. There could very well be a provision that you will not get paid parental leave for a provision of a year. And there could be provisions, and I've seen them in the context of maternity leave, which say you will get paid maternity leave for a single occasion in a 2-year period, in a 3-year period, or whatever that period might be. So that kind of information will play in an employee's decision as to whether or not they are going to take some, all, or none of their proportionate share of the parental leave. So I absolutely agree with you. Education is going to be very important.
Which
And I
leads
think-
us to, sorry, carry on.
Sorry, Pak, and I think to your point, Balindile, I think it's also important to then explain what the UIF considerations would be. And I know we're not really dealing with the UIF today, but there are certain limitations in respect of what the UIF will pay. There's certain requirements that you need to have a certain number of years of service and a certain number or a certain level of contribution in order to receive the payment. So I think all of these will need to play into this education communication scheme that the employer is going to have to put in place when implementing the changes in their policies.
Thanks for that. This leads to the almost inevitable question these days is, what about POPIA? Lauren, over to you.
POPIA applies to everything. So
Yeah, I was thinking.
it absolutely applies to this as
You've got to give it its full name, because Prevention of
Protection of Personal Information Act. So the Protection of Personal Information Act deals with what we sort of term regular personal information and then special personal information. Information relating to health is classified as special personal information, which has got more stringent requirements in order to access, process the information. And then we've also got, in this instance, information relating to children, which is, you know, place it at an even higher standard in POPI in respect of how an employer or how anyone can gather that information and process that information. So certainly when we are talking about disclosures and verification of information, employers are going to have to be extremely mindful of how they go about doing so. And presumably the employees are going to be forthcoming with this information. Why? Because they get a benefit as a result thereof. So, you know, there ought not to be any issues as a result of obtaining their consent to the accessing, processing, retaining of that information. But, you know, even if there was no consent obtained and the employer has the information, there would likely be a very legitimate reason as to why they could process it, you know, in the context of special personal information, where you are discharging a legal obligation or exercising a legal obligation, you can process that information. So here the legal basis would obviously be the BCEA and the UIF Act. So whilst POPI is definitely a consideration and one must look at all the requirements of POPI in respect of processing, over processing, and those sorts of things, employers don't need to panic too much as long as they follow their POPI rules.
Thank you for that, Lauren. We've come to the end of our presentation, but there are plenty of questions that we can deal with, and I will try and cull them and make certain that we answer themes rather than specific questions. And the first question that we haven't really dealt with is this issue of adoption leave. If I remember correctly, Henry, it's this, the right to adoption leave only applies to children who are adopted who are less than or younger than 2 years old. And the question is, why 2 years, and what do the Labour Court the High Court have to say about this?
Yes, Puck. I have some fairly strong views about this, but let me try and phrase them in a less strong fashion. I guess effectively the High Court was asked to consider whether things amounted to unfair discrimination or not, which is a very specific legal question. You know, that hence the unconstitutionality of certain of the provisions. Yeah. And I think the court used that in assessing the adoption leave cap of 2 years to say it certainly may be preferable to have a higher cap or have no cap at all, that says if you adopt a child, you are entitled to as much nurturing time with that child, however old the child is. But the fact that that isn't the position is not sufficient to be either unfair discrimination and or unconstitutional. So I can understand the judge's reasoning and how they reached that point, but I can also see the compelling counter argument, which is that the child who is adopted certainly requires nurturing. And to say that that nurturing requirement stops as early as age 2, I would like to see a lot of supporting data for that position, because to me, I would certainly have liked to see the cap higher, or if it's going to be as low as 2, and a cap's always going to be arbitrary. So if you're going to have a cap, it's always going to be some arbitrary number. You know, 2 years and 1 day you're outside, just 1 day shorter of 2 years you're inside. But I would want there to be some further interrogation of that to see if there isn't sufficient to say, well, actually, this could be unconstitutional and does need further attention when the legislature has a look at it.
Yeah, I must say I wasn't persuaded by the court's reasoning there, but it is an arguable case, and that raises the question: shouldn't these policy decisions be left to the Department of Labor rather than the courts? But that's another debate. Here's a question: how would one deal with an opportunistic claim by a non-birth mother to allow paid leave prior to confirmation by the Constitutional Court? Thus, do we really have breathing room? In other words, does the court order take effect immediately, or is it suspended in some way? And I think, Balindile, you did deal with this to some extent. Perhaps you should just go back on that and deal with it again.
Sorry, my apologies. I'd lost sight of my mute button. Pak, I think that if my interpretation that what the court order is it's not an interim order pending confirmation by the Constitutional Court. It's an interim order pending the consideration by Parliament. Then my position will be right, that it's not yet in effect. And if I'm right on that, then how you deal with that opportunistic parent for to use the words used by the questioner, I would suggest that you would then, depending on which forum you are ultimately challenged, then raise that defense there. It's always preferable not to have to get to court or to the CCMA to defend a right. So I would engage with them on that basis. And if you are unable to persuade them and they insist on suing you, then I would launch a defense. But by all means, please get direct legal advice before you take any particular action.
Thanks. There is one possibility that where an opportunistic employee may come, but not with a claim in terms of this legislation. And let's take the example of an employer that has certain amounts of paid maternity leave for a mother, and that's in the policy and it's paid. Can an opportunistic person now come and say that that policy is invalid, and rely on to say that it must be invalid simply because the Labour Court has held that the equivalent statutory provisions are invalid? In other words, in terms of saying that the agreement is the policies unfair or discriminatory, can they do that, do you think? Henry, what do you think about that?
Yeah, I suppose the essence of this uncertainty comes from the fact that the way that the judge has seen fit to write the judgment suggests that the change is immediate. as in, unlike in the other judgments, where it's clear that the next step is that it must be certified by the Constitutional Court. This judgment suggests that despite all of that happening in 18 months or however long it's going to take, this interim order is an effective order, which I don't think is correct. But if that is what the effect of the order is, I think that is, I don't know whether you want to call it an unlawful statement by the courts, but I don't think that's the correct mechanism for the court to have invoked here.
At least on all accounts, from at least social media, it appears that the applicants have made steps to get the judgment confirmed by the constitutional order. I beg your pardon, by the Constitutional Court. So at least we can keep our eyes on those developments.
Yeah, okay. The next question, which is an interesting one. How does one ascertain parenthood on the part of their farmer if there's no formal relationship? Do you simply rely on the word of the father? Can you, you know, I think I know the answer to this, but it's an interesting and important question.
Let me take a stab at this one. So in much the same way where if a father comes to an employer and say, I am about to have a child, I would like to exercise my current parental leave. And an employer will say, congratulations, please go about your business. And when you come back, please bring us the birth certificate. I think that is a reasonable proof that an employer can ask for. So I still think that would be a well acceptable requirement from an employer. In the case of a commissioning parent arrangement, there is a court order to support that. In the case of adoption, there is also a court order to support that. So it's relatively easy to get sufficient proof.
Yeah, any questions or any comments on that from anybody else in the panel? It sounds right to me, but I mean, there may be other views.
I agree with that.
Okay.
Yeah, so do I. And I think this also raises another interesting question about how far you can go in ascertaining whether someone is actually parenting. And I think in our discussions leading up to this webinar, we all settled on the position that we can't necessarily, as employers, ascertain the quality of the parenting. So one can't say, well, are you at home? Are you doing what you need to do? Are you sitting at the bar drinking all day? So I think there are going to be difficulties that come up as to where there's no formal relationship in place, formal agreement in place, you know, someone's name on the birth certificate to ascertain whether or not someone is a parent and someone is actually parenting and nurturing.
Thank you for that. The other question that's just come through, it seems to the questioner says or accepts that the 4 months leave can be apportioned by agreement between the parties, subject to a minimum of 16 weeks for the mother. But what if there's no agreement? What if there's an estrangement and the relationship, you know, they just can't reach agreement on this type of thing, or is used as leverage for another type of dispute? Does the act does the act envisage, or does the court order envisage a situation at the moment or deal with it in any way?
So maybe as a starting point, and I'll be interested, Lauren and Henry, in your views about it, what the court, the amendments by the judge, it says both employers must be notified prior to the date of birth in writing of the election. And if a shared arrangement is chosen, the period or periods to be taken by each of the parents must be stipulated. So and I think the point may have been made by Lauren earlier. It certainly is not for the employer to descend as the mediator between the two parents as to how it is that they will apportion their leave. All that the employer is actually doing is they are implementing the communicated will of those parents. And if they are in dispute about it, I think a prudent employer would say, well, you must tell me by law go sort yourselves out, formulate a position, and if by some luck both employees are employed by the same employer, great, then they will let the employer know. If they're not, I think the other employer will be waiting for the same information, and all the employers they are just implementers of the rights conferred in the BCA.
And absent an agreement, who do you default to? How do you decide who is the default position? I saw that question in the chat, and it got me thinking, and I didn't have an answer.
I must admit, I don't have an immediate answer either. But there are few cases where I think you can then, as an employer, demand an answer, because otherwise, how are you going to exercise your own obligation, rather fulfill your own obligations?
And I don't have a definite answer either, but there may be extraneous proof as to who is caring for the child that can be sought. So if it is the mother, she's having this child 6 weeks later, you know, you can't necessarily say come back if there is proof that she is in fact the one that is looking after the infant. I think that, you know, we may get into a situation where we're going to have to start looking at what kind of information we can gather in order to determine that. But I think it's going to be interesting.
I think what an employer might actually do as to safeguard themselves from this abuse, or not abuse, but from such a scenario, is insofar as they are paying for the parental leave, they can say, we will only pay you if your parental leave is shared upon you providing us written proof or written assurance as to what is a split amongst you two. So if nothing else, hopefully then the commercial consideration from the two parents who are haggling about this can then drive them to reach agreement sooner.
Agreed. But I think it is going to be tricky. We can't really descend as the employer into the private lives of our employees. And I think, you know, the point has been made more than once that, you know, the employees are responsible for these sorts of decisions.
Maybe you hedge your bets and say, look, if you two can't agree, we'll give you each two months. So best you agree if you want some other position. Because I just worry that the position surely isn't intended to be that no one gets anything, or that you then descend into this moral arbiter role and say, okay, you look like the better parent. We're going to give you, or society assumes you might be the better choice. I would hedge my bets and say, okay, you get two months each, otherwise agree something different.
Also
Yeah, and I think that, sorry, Paco.
Carry on, love.
I think that also raises some interesting societal issues here. If we look broadly at where other jurisdictions have sought to implement parental leave, it is to try and equal the playing field between men and women. And some of the most progressive societies, if we're looking at the gender gap report that is released yearly, have these sorts of arrangements in place. So I think ultimately we also need to try and reset our mindset as to who is the better parent, who is the carer, in looking at the parental leave going forward.
Suppose in the absence of agreement, the one parent could go to its employer and say, well, I want my full 4 months leave, 4 months leave. The other parent could go to its employer, his or her employer, and say, well, I want 4 months leave. And then it becomes a situation of how you ascertain which one it is, if there's no agreement between the parties. This is a fairly long question, but I think it's an interesting one. Is it not possible that birth mothers may be worse off in normal circumstances, in inverted commas, as we know it today, where the birth mother is entitled to 4 months, and in addition to this, the dad is entitled to 10 days. Therefore, the dad can take 10 consecutive days when the child is born to help the mom for the first 10 days. If the amended legislation remains as per the High Court, then the 4 months must now be shared. And if the dad takes the 10 days, the mother's maternity leave becomes less. And 4 months is already not a lot. What do you think about that comment? I found it quite interesting. Are mothers, birth mothers worse off?
I think it's yes. I think in certain scenarios, yes, they are worse off in this scenario that's painted here. Comes back to the point of this new arrangement is an improvement for a lot of people who previously wouldn't have had anything, but it is also worse for a lot of people who previously would have had the full 4 months. Worse for them very personally, them specifically. You know, whether that's better for their family unit is a different question.
Any other comments, or anybody wants to say anything?
No, I agree with Henry.
Right. I think we've got time for one more question. Two questions, really. I suppose they link. Good afternoon. What happens if one of the parents is unemployed? Is the working parent still entitled to leave? The other question is, what happens in a situation where the mother or father stay at home and the other spouse works? Will they be entitled to the full 4 months parental leave? Bali?
So the leave in the BCA is leave for an employee. So how I imagine a scenario where one of the persons is not an employee of any sorts. So in the case of a housewife, for example, the sharing of the leave can't be shared because they are not entitled to participate in that pool. So I don't see a reason why, in that example, the father cannot take the full 4 months paid leave because they have no one to share it with insofar as the other parent is not an employee.
Judging by the nods of the panel, you're in agreement. Is that correct?
Correct.
One final question, which I think is important. Most employers have a work back period for paid maternity leave. In other words, usually a 1 year period. It seems to me that some employers are saying, well, I'll give you paid maternity leave for a certain period of time. But the precondition for that is you must work back that by working for a further year or whatever time it is. Will this work back pay or now also apply to both parents, or will this be at the employer's discretion? Anybody got any comments on that?
I'm happy to take it. I mean, wherever an employer gives additional benefits over and above those which it's statutorily required to do so, it can regulate those benefits as it sees fit. In the context of things like maternity benefits and study loans and those sorts of things where work back agreements are common, there's no reason why that only has to apply to females. So that can equally apply to males. But obviously the one thing that you will need to do as an employer, if you elect to make payments for those parental leave periods, is to then amend your policy such that it is a requirement, and ensure that you then get agreement from whomever you are going to pay in respect of those benefits.
The thing that does worry me there is that you must be careful that your maternity leave policy in this regard doesn't discriminate between the man and the woman or the partners, as it were, because otherwise you enter an unfair labor practice / not dealt with in the Act, but in terms of unfair labor practice or unfair discrimination Act stuff. Right, I see it's 1:30. There are plenty of other questions, but unfortunately we can't get to them. But I want to thank you for the quality of the questions and the interesting questions, and I want to thank the panelists for their views. I found it interesting, and I hope you did as well. Thank you very much. Enjoy the rest of the day, and good luck.